Hello friends, in the series on the income tax cases, today we will discuss a very important judgment which has been decided by the Supreme Court. The name of the case is SMC Overseas Private Limited versus Commissioner of Income Tax. This case has been reported in 450 ITR, page number 1. The date of the judgment is 7th December 2022 and this matter is regarding Section 148 Assessment Proceedings. The case relates to the assessment year 95-96 and the date of the judgment is 7th December 2022. It means it has taken 27 years in the litigation of the assessee and the department. The facts of the case are very interesting and unique. In this case, the assessee claimed Section 80 HHC deduction for the assessment year 95-96 by filing the return of income. In the subsequent year, the assessee claimed bad debt by saying that the exports could not be realized. The department issued and initiated proceedings under Section 154 for the assessment year 95-96. Later on, in spite of that, Section 154 proceedings were not concluded by the department. Notice to assessee was issued under Section 148 and the assessment proceedings were completed. When this matter was before the ITAT gave relief to the assessee by questioning the assessment under Section 147 read with Section 148 by saying that if the rectification proceedings under Section 154 is pending and has not been concluded, then in that case, for the same assessment year, notice under Section 148 cannot be issued and assessment under Section 147 read with Section 148 cannot be done. The department went to the High Court against this decision and the High Court said that in the present case, the proceedings under Section 154 were time barred and hence it cannot be said that the proceedings under Section 154 is pending. Therefore, the ITAT reverted back matter to the ITAT for fresh adjudication. The conclusion is that the High Court was of the opinion that since Section 154 proceedings were time barred, hence they were understood as that 154 proceedings were not alive. So Section 148 proceedings were alive. So the matter is to be adjudicated fresh by the ITAT. The assessee filed a review petition for this decision, but the High Court declined to entertain that review petition. So the assessee was before the Honorable Supreme Court. The Supreme Court said that Section 154 proceedings were time barred or not. Whether 154 proceedings were time barred or not, this was not the issue before the High Court. And the plea of the department that 154 proceedings have been withdrawn is not brought on record. And even if the department says that 154 proceedings have been withdrawn, in that case, the department has to pass the order under Section 154 by saying that 154 proceedings have been withdrawn. So, in that circumstances, it cannot be said that Section 154 proceedings are not alive. So, the Supreme Court held that since 154 proceedings are alive, so for the same issue, Section 148 notice cannot be issued and consequently the assessment under Section 147 read with Section 148 cannot be completed. Friends, this case is very important. One pertinent question from my point of view in this question is that in this case, the proceedings under Section 154 were from the department. Whether this decision will hold good, even if the Section 154 proceedings have been initiated by the assessee. So, my opinion on that is that even if the assessee has gone for 154 application. Even in that case also, section 148 notice cannot be issued for the same assessment year without completing the rectification proceedings. At the end of this video, once again, I am repeating the name of the case. The name of the case is SM Overseas Private Limited versus Commissioner of Income Tax. This case has been reported in 450 ITR at page number 1. The matter has been decided by Supreme Court and the date of the judgment is 7th December 2022. Thank you, friends.